All right. Good afternoon, everyone, and thank you so much for attending today's event. Today, we will be tackling the topic, the new Ontario Nonprofit Corporations Act. What Ontario nonprofit and charity organizations need to know about ONCA. This act has recently been established, but it has been in works for a number of years. As of October 19th, it is now in full force. So today we have two experts on our panel who will be discussing the Act's establishment, its impacts on organizations, and what boards and governance professionals really need to know during this time. So some of the learning objectives that we've outlined include just a basic understanding of the ONCA and how it applies to you, any steps that you need to review or update, any kind of documentation or information, and really the steps that you need to take in order to ensure compliance with you and your organizations. So we're hoping that today this will be a great guide and a great framework for you all to move forward with to ensure the best knowledge for you as governance professionals and the success of your respective organizations. So today we have two panelists here with us. We have Jade Renaud. She is a corporate lawyer at Mann Lawyers LLP. She practices in the areas of corporate and commercial law, assisting clients with business, sales, and acquisitions, incorporations, reorganizations, franchisings, non-for-profits, private foundations, commercial leasing, and so much more. She's also a member of the Canadian Bar Association, as well as the County of Carleton Law Association. Today, we also have Benjamin Miller with us. He is a lawyer at Community Legal Education Ontario, but today he is in his role as policy advisor with the Ontario Nonprofit Network. So Benjamin comes to us as a policy advisor and staff lawyer. He focuses on nonprofit and charity law and policy. And today, I know that you will get a wide amount of knowledge and insights from both of them. And I also should mention that Benjamin has a JD and an MPP from the University of Toronto, as well as an MA in political theory from the University of Ottawa. So today I will be acting as moderator. I will be presenting questions to Jade and Benjamin. If you have any discussions that you'd like to have within the chat, please feel free. We would love to hear from you. However, if you do have questions, please do write them within the Q&A box, and then we can present them to our speakers at this time. I'll be monitoring both. All right, thank you so much. So let's start things off. First things first, what is the ONCA and what is its importance for Canadian nonprofit organizations?
Thank you, Tamara. So the Ontario Not-for-Profit Corporations Act, which is also known as the ONCA, or ONCA, as it's sometimes called, is a new legislation, as many of you know, that was just proclaimed into force on October 19th, 2021, in order to regulate how Ontario not-for-profit corporations are incorporated and governed and dissolved. Before ONCA, most nonprofits that wish to incorporate would do so under the Corporations Act. But the Corporations Act has been around since 1907, so it's dated. And it also governs a variety of corporations that do not necessarily have a standard corporate structure, like insurance companies and mining companies. So it became kind of a catch-all statute, and Ontario nonprofits were sort of thrown under this act with these other types of corporations, and it really wasn't doing a very good job at meeting the particular needs of our Ontario nonprofit sector. But ONCA has kind of come in to provide this standalone act and modern legal framework specifically intended to meet the needs of Ontario's not-for-profit corporations. And it provides for things like clearer rules for governance, increased accountability, more rights for members. It protects directors, in a more effective way against liability. It provides a standard duty of care for directors to act with honesty and in good faith and with reasonable care. It confirms that non-for-profit corporations in Ontario are permitted to have commercial activities as long as those commercial activities are solely intended to advance or support the nonprofit purposes of the organization. And it creates this new distinction between public benefit corporations and non-public benefit corporations, which we will explore a little bit later. So For these and so many other reasons, many of which we will cover today during this webcast with you, ONCA being proclaimed into force after more than 10 years of being in drafting is a very big deal for Ontario not-for-profits. And we are very excited to see how these changes might positively impact our organizations.
Perfect. So Benjamin, I'll throw a question to you. So what is a public benefit corporation and why is it enacted in ONCA?
Thanks so much. And before I jump into my answer, I'll start as lawyers are wont to do with three disclaimers, not just one, but three disclaimers. Number one, everything I say, and I'll say this for Jade as well, I'm sure she'll agree, is legal information and not legal advice. We don't know your specific situation. And public benefit corporations and the rules that apply to them is a really good example of where it might differ depending on your situation. Number two, my comments are about law and not best practices. So what's right for your organization will vary. I see my mission here today is to highlight options for you and to motivate you with some different reasons why things are in the Act from ONN's perspective and what we hope for the sector. But I'm not here to say this is what every organization needs to do because organizations are vastly different. And thirdly, we're discussing the ONCA here today. We're not discussing funder expectations. And this is crucial from a policy perspective. There's the law, but then there are all the other influences you face as an organization. And especially when it comes time to talking about financial review, we'll fully acknowledge it's going to take time for funders, member standards organizations, and so on to catch up to the flexibility that now exists in the law. So this is by no means intended to be a comprehensive discussion. So with those disclaimers in mind, I'll actually answer your question. So what's a public benefit corporation and why is it in the Act? Under Ontario Corporations Act, there was kind of a level playing field for all nonprofits. So whether you were a movie club that you just met at home with your friends and you watched movies, or you were a complicated health organization or a shelter or something like that, fundamentally you're facing the same set of corporate rules. But we know the sector is diverse. They're organizations whose primary purpose is to serve their members, and they're essentially private organizations. And there are more public-oriented organizations whose purpose is to take in money from the public, to serve the public. And it's not necessarily appropriate that these diverse sets of organizations should all face the same set of rules. So the Canada Not-for-Profit Corporations Act, which is the federal equivalent statute, and the Ontario Not-for-Profit Corporations Act tries to remedy this situation by making a distinction. By default, all organizations face the same set of rules under the ONCA, but then certain organizations that are termed public benefit corporations, if they meet certain criteria, face additional rules. So that raises two questions. Who are these organizations and what are the additional rules? So there are two ways that an organization can end up being a public benefit corporation. So one, if you're a registered charity, you're considered a public benefit corporation. And it might be intuitive why a charity would be expected to face additional rules because in principle, charities are for the public benefit. The second category of organizations, if in year one, so in a given year, the organization receives more than $10,000 from either of two sources, either one, government, so that means federal, provincial, or municipal government, or an agency, so that includes the Ontario Trillium Foundation, right? So if you receive more than $10,000 in grants or financial assistance from government, then in the subsequent year, you're a public benefit corporation. And then that status keeps going over each year that you qualify. If you receive more than $10,000 in donations or gifts from individuals, persons who are not your members, directors, officers, or employees, right? Then the year that you qualify, the next year, you're a public benefit corporation, and it keeps carrying over. The big picture here is basically if you're an organization that receives money from the public, whether it's from the government or people not connected to your organization, the idea is that you should be subject to additional rules. So What are those additional rules? There are three main rules that you might want to take an interest in. So number one, there are additional financial review standards, which we'll talk about later on. Number two, there are limits to who you can give your property to if you dissolve. So dissolve means you end as an organization. If you have any property left over after paying all your creditors and so on, the question is, who does the money go to? Public benefit corporations, and for 3 years after they have that status, so it extends for a little while, can only give their property to government, federal, provincial, or municipal, or if they're a registered charity, other registered charities with similar purposes, or if they're a public benefit corporation that is not a registered charity, other public benefit corporations with similar purposes, or registered charities with similar purposes. So you may already have a dissolution clause. It's called the line that governs where your property goes. You may already have that in your governing documents. So this is one of those things you may want to check to make sure it's in line. The third rule that public benefit corporations need to keep in mind is under the ONCA, only up to 1/3 of your directors can be employees. And that includes non-voting directors, that includes ex officio directors, so people who are on your board by virtue of their office, right? So I'm not saying it's a good idea to have employees. It depends on your situation. And if you're a charity, there are additional rules and restrictions for having employees on your board, and conflict of interest rules always still apply, but ONCA allows up to 1/3 for public benefit corporations to have employees on their board.
All right, perfect. I see we have some Q&A questions, but I think we'll go through the questions we've decided on right now, and then we'll take the questions as they come towards the end. All right. So how does ONCA affect the way that nonprofits do audits or any other financial review?
So I'll take this one. So under Ontario Corporations Act, there was a straightforward rule, but it was pretty inflexible. The rule was basically if you had under $100,000 in annual income, by default, you had to get an audit, but at your members meeting, you could pass a resolution and waive that audit. So just do your financial review in-house, so to speak. Above $100,000, you had to get an audit. So under ONCA, one of the nice new things is that there's flexibility to better reflect the diversity of the sector. So by default, all organizations have to get an audit, but some nonprofits have the option each year of passing what's called an extraordinary resolution at their annual members meeting. And then depending on your income threshold, you may have the option of getting a review engagement or a financial review instead, or waiving all external review. So that raises two questions, I'm sure. Number one, what's an extraordinary resolution? What makes that resolution so extraordinary? And number two, what are the income thresholds at which you can get a review engagement or waive all external review altogether? So a resolution, that's the thing that at a members meeting you pass. It's like a motion or so on. Maybe you're changing your bylaws, you're changing your name or something. And unless your bylaws, which is another word for your governing rules, you may call it your constitution or so on. Unless your bylaws say something different, the default is a resolution needs 51% support to pass, a simple majority. An extraordinary resolution needs at least 80% support to pass. So by default, you need to get an audit. And if you want to get something else, you need at least 80% support of the voting members at your members meeting. So the rule is the same for under $100,000 in annual revenue. You pass an extraordinary resolution and you can waive all external financial review. For organizations between $100,000 and $500,000, it depends if you're a public benefit corporation or not. If you're a public benefit corporation, you can pass an extraordinary resolution, but you have to at least get a review engagement or a financial review, synonymous. If you're not a public benefit corporation, up until $500,000 in annual revenue, you don't even have to get a review engagement. So you can do all your financial review in-house. Now, above $500,000 in annual revenue, if you're a public benefit corporation, you still have to get an audit. So you don't have any options now. If you're not a public benefit corporation, you can pass an extraordinary resolution that says we'll get a review engagement instead, but you have to at least get a review engagement. So the new thing here is that there's new flexibility between $100,000 and $500,000. And for non-public benefit corporations under ONCA, you never have to get an audit. Now, remember, your funders may have different expectations. If you're subject to other regulatory authorities, they may have different expectations. We're just talking about ONCA.
All right, great. Thank you for that. So what rights do members have with ONCA? Jade, if you could let us know.
So under ONCA, members have been given some new rights. Voting members specifically more than non-voting, but all members have been given new rights under ONCA, which is super helpful. So under ONCA, all members have a right to obtain a free copy of the corporation's letters patent and bylaws. So the letters patent is the document that you receive from the Ontario government when you incorporate, and it sets out information like the corporation name, its registered office address, number of directors, and that type of information. Your bylaws are the rules that govern your corporation in conjunction with the act. So you have a right as a member to obtain free copies of those documents. You also have a right as a member to view and obtain copies of the corporation's financial statements, which is super helpful because that was not a rule before ONCA came into force. You also have a right for a reasonable fee to view and obtain the members list of the corporation. So this is the list of names and addresses of the members of the organization. And that is only applicable if your purpose for obtaining that list is directly related to the nonprofit's activity. So you can't just use it for anything. It has to be directly related to the nonprofit's activities. And at least one class of members must have the right to vote. If you are a voting member, you have even more rights. You have the right to submit proposals to the board of directors for topics to be discussed at meetings of the members. You have a right to nominate directors in the form of proposals, as long as you have at least 5% of voting members sign off on your proposal, and your bylaws can actually set out a lower percentage than 5. You have a right at annual general meetings, which under ONCA are just simply referred to as annual meetings, to discuss any matters that would qualify as a proposal, even if you have not submitted that topic in writing prior to the meeting. And voting members now have the blanket right to remove directors from the board by majority vote at a special meeting, regardless of what the organization's letters patent or bylaws state regarding that matter. So lots of new rights for members under ONCA.
Perfect. That definitely sounds very promising. So Ben, could you elaborate on that a little bit more? So why is it important for members to have these kind of rights?
Sure. So I'll start with the following statement, because I often meet nonprofits who are anxious about the ONCA. They're anxious about knowing what they need to do to comply, and I appreciate the desire, the eagerness to want to comply. But here's one big reason you don't need to be anxious. There are no ONCA police. It's nobody's job in the government to knock down your door and ask you, have you complied with your bylaws? And that's quite intentional, because the way the act is set up, the members have the ultimate power, right, though not the legal duty, to make sure you are compliant with the act. So the members are a big source of accountability for the organization. And, talking a bit beyond law for a moment, when it comes to an organization that is accountable to its broader community, that's accountable to its broader stakeholders, that there are only so many people you can fit around a board table. But memberships can be structured in very diverse ways to account for the different interests. There can be voting members, non-voting members. You can get very creative in how you include increasingly wider groups of people. So Ontario Nonprofit Network has a project called Reimagining Governance, where we invite organizations to rethink and reimagine the traditional kind of standard. You have limited number of members because you don't want the administrative inconvenience of having more. You have your board, and that's kind of how governance happens. Organizations are increasingly shifting towards a much more holistic perspective of what it means to have good governance. And members' rights from ONN's perspective is a part of that. Now, I will address the question because I often get it. Can you still have a structure where your only members are your board and your board your only members? Yes, it's still possible under the ONCA. So reflecting that different structures are needed for different organizations, that's still the case. However, an empowered membership has all kinds of benefits for the sustainability of the organization, for the accountability of the organization, for the trust, which is part of the economic advantage that nonprofits bring to the market. So for all these reasons, the rights that Jade described are very important.
Perfect. That's great. So Jade, Benjamin, thank you both so much for sharing that and laying out that foundation. Jade, could you go on and help us to understand, how do the changes that ONCA is presenting and bringing about, how do these affect meetings of directors and members?
So the new changes under ONCA with respect to meetings primarily affect members' meetings, but the changes overall provide more flexibility for meetings in general, directors and members' meetings. So for members' meetings, for example, your bylaws can now set out a lower percentage of voting members required to demand or requisition a meeting of the members. So under the Corporations Act, the old rule was that members holding at least 10% of votes were required to demand or requisition a meeting, and your bylaws can now set out a lower percentage than 10. When it comes to location of a meeting of the members, they must be held in Ontario in the location set out in your bylaws, as long as your letters patent don't state otherwise, or the voting members haven't agreed on another location. If your bylaws are silent on location, then the directors can ultimately decide where the meeting will be held. Now, your bylaws can also set out any quorum for members' meetings. So there's some more flexibility there. Quorum being the number of members required to be present at the meeting in order to conduct business. If your bylaws are silent on quorum, they don't set one out, the default quorum will be a majority of members entitled to vote present at the meeting, either in person or by proxy or by whatever other methods of participating are set out and provided for in your bylaws. If you have a quorum at the opening of a meeting, but that changes throughout the meeting and some people leave and you no longer have a quorum, you can still proceed with the meeting and conduct business. If you do not have a quorum at the opening of the meeting, then you can adjourn the meeting, but you can't conduct any further business. So that's an important piece to keep in mind. Your letters patent can also set out any number of votes per member. So we always recommend that, even though it's not necessarily a requirement, and we'll review this again later, we always recommend that you include in your letters patent the names of the classes of the members and the voting rights of each class in your letters patent as opposed to your bylaws. If your bylaws are silent on number of votes per member, then the default rule is 1 vote per member, and that's what it will look like. Voting is by show of hands as the method of voting, unless your bylaws provide otherwise, more flexibility there, or the members demand a ballot, which they can do. Your bylaws may also give the members the right to vote by mail, electronic, or telephonic means, as long as your organization can confirm that all of the votes that have been given by voting members only, and as long as your organization cannot identify by which method each voting member has chosen to vote. Another really, really important piece. Your bylaws can now also provide for a right of the members to hold a meeting entirely by telephonic or electronic means. This is an important consideration in a time like today where we're dealing with a pandemic and safety issues. That can be a nice option to have if it works for your organization. One of the biggest changes that we have seen from the Corporations Act to the Ontario Not-for-Profits Act with respect to members' meetings is that members no longer have a blanket right to vote by proxy. That was a rule in the Corporations Act. They had that right. They were entitled to do that. And now under the Ontario Not-for-Profit Corporations Act, in order for members to be permitted to vote by proxy, that right needs to be set out in the bylaws. So if you want to give your members that right, make sure that you put that in the bylaws. And if you do include that right in your bylaws, You can also at this time decide whether or not you would like to include a requirement that proxy holders must be members, because that's also not a hard and fast rule. So if you'd like that to be a rule, then you need to include that in your bylaws as well. And when it comes to notice for members' meetings, notice must be given between 10 and 50 days before the meeting to all members entitled to receive notice, to all directors, and to your auditor or the person that you have appointed to conduct a review engagement based on your categorization as either a non-public benefit corporation or public benefit corporation, as Benjamin discussed earlier. And in that notice of a members meeting, you must also include any members proposals that have been submitted before the meeting, unless they fall under certain exceptions in the act that permit the corporation to not include them in the notice. But if they don't fall under one of those exceptions, they need to be included in the notice of the meeting. So that's members meetings, lots of flexibility there. For directors meetings, there's more flexibility for them too. So your letters patent and your bylaws can provide for any quorum, same rule as members meetings, although for your members meetings, it needs to be your bylaws. For directors, it can be set out in your letters patent or your bylaws. If your documents are silent on quorum for directors meetings, the default quorum will be a majority of the either fixed number of directors or the minimum of the range of directors required by your letters patent, whatever you have set out in there, which is another reason why it's important to include, although not a requirement, the number of directors in your corporation in your letters patent. Your letters patent and bylaws can also provide for any location to hold directors meeting, CA for flexibility, and any notice requirements. And any director is permitted to participate in a director's meeting electronically, as long as all of the directors consent. The old rule used to be as long as all of the directors participating or attending in the meeting consented, but the new rule under ONCA is that all directors of the organization need to consent, and unless your bylaws state otherwise. So your bylaws can state that directors are not permitted to attend meetings electronically or virtually, but if you'd like to give directors that option, then put that in your bylaws. Okay, so quite a lot of flexibility for organizations under ONCA when it comes to meetings.
Wow, that's great. I love that amount of information. That's amazing. One aspect that's a really big key for governance professionals is meeting minutes and record keeping. It's something that's definitely a significant part of the role. What is ONCA's impact on those processes? Could you elaborate more on that, Ben?
Yeah, absolutely. But before I jump into the minutes, just listening to Jade, I reflected on one of the great strengths of ONCA is that it gives us all a reason to use the word telephonic, which in my mind is an amazing word. It's like, I would like to order pizza today. How? Telephonically. So let's all just use that word a bit more. I think it's great. Okay, minutes, your actual question. So I get a lot of questions about minutes. So the first and simplest point to start at is what minutes do nonprofits actually need to keep? 4 kinds. So number 1, board meeting minutes. So the board of directors, their meeting minutes. Number 2, members meetings, the minutes of the members meetings. Number 3, board committee meeting minutes. And here we start, not all nonprofits know about that. And then number 4, member committee meeting minutes. And it's rare that I run into a nonprofit that's aware of that requirement. So minutes are very important for the institutional memory of the organization. It's the backbone in terms of being consistent with the decisions you took and carrying them out, being accountable and keeping a record of who said what. For individual governance professionals, minutes are super important for taking note of if you disagree with the decision that's taken. You have the right to ask that it be recorded, your disagreement and the reasons for your disagreement, right? Which can be very important if that decision gives rise to liability, but also it can be important just to document the diverse viewpoints and the decision-making process. So I think it's a way of internally keeping yourself accountable. It's sort of like, when a meeting's being recorded, everybody, sits up a bit straighter kind of thing. So effective minutes are a good way to instill a sense of decorum and the official nature of the business you're conducting. So those are the 4 kinds of minutes. Other questions I often get are, can we keep our minutes and our records more broadly digitally? So this is one of the nice new things about the ONCA. So as Jade mentioned, the Ontario Corporations Act was very dated. Part of the update with the ONCA is the recognition of all kinds of online meetings, but then also online record keeping and then online processes in interacting with the government. So the answer is now, yes, you can keep your minutes and your records digitally. Now, technically, what ONCA says is you can keep it digitally as long as that's okay with the CRA. But the CRA's position has been in recent years, encouraging. As long as your digital records continue to be available from your headquarters, or for certain records, your board has the option of designating another place by resolution of a board meeting, designating another place within Ontario. As long as the records are available to be accessed by people who have a right to them at the headquarters or another place in Ontario, you can keep your records outside of Ontario. That's code for you can use cloud. Now, some of you may be scratching your heads and thinking, well, we've been using cloud for years. Well, as I said, there are no ONCA police, there were no OCA police, but now it's unequivocally the case that we can use cloud. So if that was one of the reasons that was keeping you back from engaging in a digital transformation of your record keeping and more broadly, well, that's one less barrier, less reason to hesitate. And certainly we encourage nonprofits to take advantage of new technologies to the extent appropriate for their case. Another question I get frequently is, what about in-camera minutes? So to clarify, in-camera minutes are minutes where, because of the sensitive nature of the discussion, the attendees at the meeting say that everybody who is not absolutely required to be there leave the meeting. So you may be discussing a sensitive HR issue, some kind of complaint, or a delicate health issue. There are all kinds of reasons people have in-camera minutes. ONCA does not directly address in-camera minutes, but what it does say is that in terms of who has a right to access board meeting minutes and board committee meeting minutes, it is 1, the directors themselves. And by the way, if you're denying a director access to the minutes, that's a red flag for other reasons. And unfortunately, I encounter that situation all too often. Number 2, the auditor or financial reviewer, if they deem it important for the work that they're doing. And number 3, a court-appointed inspector, which is a rather unusual case. So really, you're dealing with the first 2. Notably absent from that list are members and members of the public. So some organizations may say in their bylaws, yeah, the minutes of board meetings, we post them online, they're available to the public. If that's what your bylaws say, then that's great. And then you may want to consider reviewing your bylaws to take into account how you're going to handle in-camera minutes. But if your bylaws don't say anything, then in-camera minutes are perfectly acceptable. You're not legally required under ONCA to provide those minutes publicly to people who weren't legally required to be at the board meeting. Now, whether it's a good idea, when you shouldn't, even if you can under ONCA provide your minutes to others, that gets into privacy law, that gets into employment law, that gets into lots of sensitivities that are very case by case. But the bottom line is in-camera minutes are okay under the ONCA. The last thing I'll note is that one of the nice things about ONCA is that it's a much clearer piece of legislation than the Ontario Corporations Act, which was difficult to navigate. One of the ways that ONCA is clearer is that it has some nice sets of regulations. I bet you never thought you'd hear that expression ever said. It's got some nice sets of regulations. One of which includes a list of the records that you need to keep under ONCA. A lot of them, not all of them. So I would encourage people to check out that set of regulations, and then you get a nice list, and you can create a checklist for the records you need to keep in writing.
All right, perfect. Very comprehensive. I love that. Thanks. So Jade, now I guess we'll be moving on from more of the foundational aspects of ONCA, what it is and what's new. Let's look more towards organizations and really what they can do to ensure their compliance. What are those first steps that boards, governance professionals, organizations should be aware of in terms of that compliance?
So the first thing that you should do when desiring to become compliant with ONCA is to determine whether or not ONCA applies to your corporation. So as of October 19th, 2021, when ONCA came into force, it automatically applies to Ontario corporations without share capital. So those are Ontario corporations that do not issue shares. ONCA does not apply to corporations incorporated under the Canada Not-for-Profit Corporations Act. So it doesn't apply to federal corporations. Most corporations sole, corporations that are governed under the Cooperative Corporations Act, so most co-ops, insurance corporations under the Corporations Act, corporations incorporated for the construction and working of a railway, and corporations with social purposes. Although keep in mind that if your corporation does have social purposes, you will have 5 years from the date that ONCA was proclaimed into force. So you will have until October 19th, 2026 to file what are called articles of continuance to continue your corporation as either a corporation without share capital under ONCA, a co-op under the Cooperative Corporations Act, or a corporation with share capital under the Ontario Business Corporations Act. So something to keep in mind. If ONCA does apply to your corporation, then you will have 3 years from when ONCA came into force. So you'll have until October 18th, 2024 to review and update your letters patent, which are now called articles of incorporation, and your bylaws to bring them into compliance with ONCA. From now until that date, so until that transition period has expired, you can rely on the current provisions of your letters patent and your bylaws, as long as those provisions either already happen to be compliant with ONCA or are compliant with the act that governed your organization prior to ONCA coming into force. So your letters patent and your bylaws and any amendments that you may have made to either of those. So for example, if you filed supplementary letters patent, amending your letters patent, these documents can typically be found with your other corporate records, possibly in a minute book, either at your head office or possibly with your corporate lawyer. They might also be found in board orientation packages or grant applications. If you cannot locate your letters patent, you can order a copy from the Ontario government for a small fee. And if you can't find your bylaws, try to pull together the resolutions that have been passed by the organization and any minutes of meetings to gain an understanding of the decisions that have been made within the organization to date, and bring those to your lawyer, your corporate lawyer, and have them assist you with rebuilding your bylaws. So when we are reviewing our letters patent and our bylaws, we're looking for 3 different types of provisions. So 1, we're looking for provisions that must be updated in order to become compliant with ONCA. 2, we're looking for provisions that may or can be updated now that we've been given some flexibility and we might want to take advantage of that and make some decisions that are particular to our organization. And 3, we're looking for provisions that might be redundant and can be removed completely from our documents. So we'll start with letters patent. So under ONCA, there are a few pieces of information that are required to be set out in your letters patent. And that includes the corporation's name, the registered office address, and the corporation's objects, which are now called purposes under ONCA. So when you're taking a look at your letters patent, ask yourself, when you're looking at that list of objects, ask yourself whether those objects accurately reflect your corporation's current and future purposes and activities. And if they don't, then they should be updated to reflect those current purposes and activities. If your corporation has any commercial purposes, then you need to include in your letters patent a statement that says that those commercial purposes or that commercial purpose is solely intended to advance or support the nonprofit purposes of your organization. There are also some optional provisions. So while they're not a requirement, we recommend that you include them in your letters patent for the sake of clarity. One of those being number of directors. You can either set out a fixed number of directors or a minimum and maximum number of directors, keeping in mind that you must have at least 3. if your corporation has 2 or more classes or groups of members, there should be a provision providing for the number of classes and the voting rights for each class. So that includes whether or not they are entitled to vote and how many votes each class is entitled to. I saw somebody ask a question in the Q&A, which I can respond to now, regarding ex officio members and whether or not they have an automatic right to vote. You need to set out, at the very least in your bylaws, if not in your letters patent, the names of the classes or groups of members and their voting rights. So ex officio members do not automatically have a right to vote, but they will have a right to vote if you set that out in the bylaws when you're describing the voting rights of each class or group of members. And the last provision that is not required but is recommended is a statement, if your corporation is a non-public benefit corporation, is a statement describing, and Benjamin mentioned this earlier, how any remaining property will be distributed upon the possible dissolution or winding up of your organization. And that just provides for clarity in that situation if that was ever to happen. So we now have covered mandatory provisions, and we have covered provisions that we recommend but are not necessarily requirements. Your letters patent and your bylaws might also contain provisions that are now redundant and can be removed. Usually we see these in letters patent, but they may also have slid into your bylaws. So you can take a look in there for them as well. These provisions are usually what we call power provisions, and power provisions grant the corporation with the rights to do certain things. Usually that includes owning, buying, and selling property. And it includes things like borrowing money on the credit of the corporation. And the reason why these provisions and these granting of rights are now redundant and do not need to be included in your documents is because ONCA automatically grants corporations with the rights of a natural person under the law. And these are considered rights of a natural person. The Corporations Act actually also granted those rights to the corporation subject to the act. So these are provisions that, while it's okay to keep them in your documents, it's not an issue. They can kind of clutter up your documents and add, just additional paragraphs that you don't necessarily need. So they can be removed. So you're aware of that. Keep in mind that if your organization is a charity, if you have charitable registration, the CRA and the Ontario Public Guardian and Trustee must approve any changes you make to your letters patent. So you can run the risk of losing your charitable registration if you don't go through the CRA and Ontario's Public Guardian and Trustee when you're making changes to your letters patent. And if you change it in such a way that it was different than it was when you obtained that charitable status. So make sure that you are compliant with the CRA's protocols and the Ontario Public Guardian and Trustee if you are a charitable organization. So those are your letters patent. Your bylaws are probably going to be the document that requires most of the time and work to review and update. And that's just simply because they contain so many more provisions and they impact one another. And it takes time to kind of parcel through them all and figure out what you want your organization to look like. The Ontario government has released what they're calling standard organizational bylaws, and they may not be appropriate for all organizations. In fact, they won't be, but they might be helpful for some organizations in developing language for particular provisions in your bylaws. Community Legal Education Ontario has also done a great job at releasing some helpful online tools and references for assisting organizations with reviewing and updating their bylaws. And some of these tools set out the differences between, the Corporations Act and the Ontario Not-for-Profit Corporations Act. Some of these tools give, options for different provisions that would comply with the new act. So these tools can be super helpful if appropriate for your organization. But often with a process like this, that can become complicated quite quickly and can require more revisions than you might realize, especially if your documents are very old. One of the best tools that you can really have to ensure compliance is the assistance of a lawyer. So we do recommend that you involve a lawyer in that process. So for today's purposes, although your bylaws should be reviewed extensively in full, we will cover kind of the two major sections that you should be kind of zeroing in on and drawing your attention to in your review. One of those being your membership provisions. So when you are reviewing your bylaws and you're looking at your membership provisions, ask yourself whether your current membership structure still meets your organization's needs. So if you have, for example, more than one class of members, ask yourself, are the different classes still appropriate? Are there meaningful differences between the rights and obligations of these classes? Would it make more sense to merge them together into one class or to keep them independent of one another? And the answer to these questions will be specific to you and your organization. Excuse me for just one moment. Thank you. Your bylaws must also set out the conditions required for membership in each class or group of members. So I saw another question floating around in the Q&A, and they're wondering, what are members? And we often, Benjamin and I often receive questions where people are a bit confused between the differences in the people involved in your organization. So there are really, when you get down to the bare bones, 3 subsets of people or groups in your corporation. One of those being members, and you can have different classes and members. And the members are the ones that have the right to elect directors. And if you're voting members, you're the ones that have those further voting member rights that I discussed earlier. And then there are directors who sit on a board of directors, and they have their own rights. One of those being that they appoint officers of the corporation. And then you have your officers, and officers can have really any title, but often those look like your president, your vice president, your secretary, your treasurer. Maybe you have a CEO or a financial officer. There are no hard and fast rules about titles for officers, but those are the 3 main groups that apply, not just for nonprofits, but for all corporations. You have your members, you have your directors, and you have your officers. Okay. So you want to set out the conditions required for membership in each class or group of members. So within that group of members, not directors and not officers, members, you might have different classes or groups. Some of them might be ex officio members based on or by virtue of their office in one of those other positions. They might also be a director and an officer. And because they have that position, they're automatically a member if your bylaws provide for that. But you'll have different groups of members, or maybe you'll have one group. And there need to be conditions required for you to become a member. So how do I become a member? What qualifications do I need? So you need to set those out in your bylaws. So ask yourself, can only individuals become members? Can business entities like corporations and partnerships become members? Does the board need to approve memberships, or can members just submit their application, and once they submit that, they're a member and that's it? Do members need to adhere to your corporation's particular mission, vision, and values? That might be really important. Does the corporation have a handbook or a set of policies or rules separate from your bylaws? And we see this quite often, and can be helpful in certain circumstances, that members must adhere to. Are there certain fees? And although we don't recommend you set out the specific fees in your bylaws, because those can change and you don't want to have to change your bylaws every 5 minutes, but are there certain fees or dues that must be paid in order for your membership to be considered in good standing? So these are all considerations that you want to kind of take under advisement and consider when you're thinking about the conditions that are required to become a member in each of those classes or groups of members, or maybe there's only one class. Whatever it looks like, there needs to be conditions set out in your bylaws, okay? If you have 2 or more classes of groups or members, you must also set out not only the conditions for how that person can become a member in that group, but how to withdraw from that particular class or as a member in general, how to transfer your membership from one class to another. If transferring your membership is permitted, you don't have to permit that, but if you permit it under your bylaws, you have to explain how a member can do that and how membership in each class ends. So for example, if a person passes away, if they are not in good standing, and you can set out a definition of what good standing for a membership means in your bylaws. So these are all really important considerations and things to set out. If you would like the directors or the members or a committee of directors or members to have a right to discipline members and terminate memberships, you need to include that right in your bylaws, or it's not a right. So if you want them to have that right, make sure you set that out. And if you do set out this right in your bylaws, you also need to set out how and when that right can be exercised. And ONCA does a really good job of setting out examples of that and the requirement for how disciplining or terminating memberships must be, exercised in a fair and reasonable manner, and the opportunities that that member might have to be heard or to kind of appeal that decision, and beyond. So ONCA does a really good job of setting that out. So those are your member provisions, although I guess one final one would be what we discussed earlier, the provisions with respect to members' meetings. So take advantage of that flexibility we now have with members' meetings, and make sure that you've set out in your bylaws the quorum that works for your organization, the location that works the best for having members' meetings, the methods of voting that are most appropriate for the members involved in your organization. Take advantage of that flexibility that ONCA provides and the time you have now to revise your documents, and tailor those provisions to your needs. So those are your membership provisions. The other major section that you're going to want to take a look at and review are the director provisions. So take a look at your director's provisions. If your director's provisions state that directors must also be members, ask yourself if this requirement still works for your corporation, or if you might benefit from removing that requirement altogether and allowing for more flexibility on your board. And again, this is very organization specific. Benjamin touched on this earlier, that these are all kind of case by case, and what works for your organization might not work for another organization. So keep in mind what your particular needs are. And confirm that your provisions regarding directors' meetings, the same as we just discussed for members' meetings, are set out and tailored to your needs. Location, quorum, whether or not directors can attend meetings electronically, and that sort of thing. You should also be aware of the fact that now under the Ontario Corporations Act, directors can only be elected for a term of 4 years, and then they can be re-elected. And there is no limit on how many times they can be re-elected under the Ontario Not-for-Profit Corporations Act at this time. But they can only be elected for a single term of 4 years. So if your bylaws set out, for example, that the directors can be elected for a term of 5 years, that needs to be changed. You can also have a provision setting out rolling terms. So the directors do not need to have all of the same term. You can set out a rolling directorship if that suits your corporation better than having just a single term for everybody. And finally, any other provisions in your bylaws dealing with things like indemnification of directors and officers, the corporation being able to obtain insurance, conflicts of interest, those types of provisions should also be reviewed and revised to correspond with the language in ONCA, as those things have now been revised under the new legislation, and you may need to make some changes to those as well. And I guess the final thing, which Benjamin already mentioned, is determine whether you're a public benefit corporation or a non-public benefit corporation, because this may impact some of the provisions that you include in your letters patent or your bylaws. So as we discussed earlier, determining how that property will be distributed if you're dissolved or wound up if you're a non-public benefit corporation. It's one of the provisions that we recommend you include in your letters patent, as we mentioned earlier. So make sure you've determined which category your organization falls into. And I'll leave you off with this question with a final note, that in some cases where bylaws are super outdated, it can be at times much more efficient and cost effective to start from scratch and have your corporate lawyer prepare for you a new set of bylaws that meet your organization's current and future needs and are already compliant with ONCA. And that can sometimes be the better choice.
Perfect. Thank you so much, Jade. Much appreciated. Ben, I know that you are working with the Ontario Nonprofit Network as their policy advisor. Do you think that the ONN has any hopes for how nonprofits will take advantage of these new changes?
Yeah, absolutely. Before I jump in, firstly I just want to thank Jade for the excellent detail. I've been in a number of these sessions, and they rarely go into such detail. So thank you to Jade for that. And I also want to zoom out from that detail and take a deep breath with everyone, because I know you have diverse reasons for being in the room here today. Some of you might be excited by that kind of detail. There's usually maybe one person like that in an organization. Some of you may kind of understand this is something you need to do, but you aren't particularly thrilled. Some of you may be anxious or intimidated by this whole process, given just how much detail there is to it. So I just want to pause to reflect on the fact that, firstly, there's a 3-year transition period, as Jade's already mentioned. So this isn't something that needs to be done by year end, unless you have other plans to change your letters patent for more urgent reasons. You've got that 3 years. And secondly, there's what the ONCA requires, but then there's the bigger picture question. And this is the first place I'll start with what ONN hopes for organizations. It's that ONCA has your attention now. People are looking at their governing documents, in some cases, maybe for the first time in a few decades. And as Jade's already said, it's an opportunity to ask the fundamental question, does any of this still make sense for us? So you can get lost in the weeds of all your rules, but it is helpful to zoom out and ask, is this how we actually operate? Is this how we want to operate? And if you ask that question without paying attention to the law, it's then more helpful to come back to the law and say, okay, this is how we actually operate. This is how we want to operate. How does ONCA enable that? Where does ONCA fit into that? Where do we have to, where do we have the opportunity to take advantage of new things in the ONCA? Where does the ONCA maybe set limits on how we're doing things such that we need to change? So the first thing that ONN hopes for organizations to take advantage of is the opportunity of the process that ONCA compliance represents. That it's an opportunity to ask big questions about your governance. The second question, or the second thing we hope organizations take advantage of, is the educational process that is coming into compliance with the ONCA. So Jade mentioned that lawyers can be enormously helpful in the process, and that's certainly true. What I would add is that the involvement of a lawyer is not an all or nothing question. It's not the lawyer does everything for you or you don't go to a lawyer. There's an enormous amount of that you can do as part of this process, that you can do for yourself, and that the act of doing for yourself is actually part of the value of the process. Because in the act of getting your committee involved, in the act of getting more than just the keeners looking at the governing documents, that's actually part of the value that ONCA adds. Because ultimately, ONCA is not about getting your documents up to date. That's obviously important and necessary in many cases, but that's not what legal compliance is. It's not we got our documents up to date and we filed it away. It's how are you living with the law after you've updated your documents? How are you taking the principles, the ideals, the due process that you imagined in your documents, and you're actually putting it into practice on a day-to-day basis? And that's something that you can only do for yourselves. Nobody else can do that for you, however much an expert they are. So what ONN hopes organizations will take out of this process is that they'll see, they won't get lost in the weeds, though the details are very important. They'll see the opportunity this represents for renewal in your governance, the opportunity this represents for education in your governance, and that this will be part of a broader sort of modernization of the sector in professionalizing our practices. Now, that's kind of the high level big picture. But ONN, calls ONCA our founding and forever issue, because ONN has been involved with the ONCA since before it was even a bill. And there are many things that ONN has lobbied for over the years to be included in the Act. And so we hope that, not in every case, but for the organizations for whom it is appropriate, we hope those organizations do indeed take advantage of it. So, for example, there are new financial review flexibilities, and it's going to be a question for funders and for membership standard setting organizations, whether an audit makes sense in every case, or whether a cheaper or faster financial review processes are appropriate for certain types of organizations of certain sizes. This is part of digital modernization. We do hope that organizations take advantage of the new kinds of record keeping flexibilities and so on. We hope, and this has been illustrated quite unfortunately over the pandemic by force, that online meetings, hybrid meetings, sometimes important, some people online, is sometimes necessary in a crisis, but it's also a question of accessibility and inclusivity. So we hope that organizations come out of the ONCA more accessible, more inclusive, more flexible, more empowered, etc., and more educated about their rights and obligations in this whole process. I'll close my answer to this question with an example that I think illustrates a broader principle. That in governance, we want strategic thinkers that think about the big picture, right? But governance is also about those really particular details that Jade describes. The difficulty often is connecting the vision up here to the details down here. So I'll give you one example of where I see an opportunity that could otherwise just be treated as one more rubber stamp red tape exercise. So under the ONCA, when does somebody officially become a director? It's not when you elect them as director, because then you could elect anybody as a director without telling them, 3 years later, say, haha, you've been liable this whole time, which is funny for a certain type of person. That's not when they become a director. They become a director when they officially sign a document, a director consent form. And it doesn't have to be a very complicated form. It could just be, I so-and-so agree to be director of such and such organization as of such date. And then you maybe include the address of the director for certainty so you know who you're talking about, right? So that could just be a piece of paper that you need to sign and then you file away somewhere. Or that moment of consent, that moment of informed consent can become a crucial point in the onboarding process of the director. Do you really understand your duties? Do you really understand the rights that you're entitled to by virtue of you consenting to be a director of this organization? There are lots of little details in the act where it could be just red tape, it could be just so much paperwork, or it could be a much more meaningful part of making your organization's governance better. Finally, I will put in the chat a link to the Clio resources that Jade so generously alluded to, and you can see for ourselves our lovely resources.
Awesome, that's great. Thank you so much. We'll be sure to include that in our follow-up to the event. And yes, Jade, if you have any other resources you'd like to throw in as well, do connect with me after. We can do that. Jade, what approach might organizations take in making changes to their constating documents?
So as previously mentioned, it's always a good idea to work with a lawyer during this kind of a process where it can become complicated and require a number of revisions. And you want to make sure that your provisions are consistent with one another, that if you change one thing and that impacts something else, your lawyer might have the eyes to catch that and can kind of check off all those boxes for you and help you better ensure compliance. So it's always a good idea to have a lawyer. And even if you do have a lawyer, one of the positive approaches that can be taken for this kind of a process is to gather together a small group of stakeholders in your organization. So different people in your organization, maybe that includes some members, maybe includes some directors or officers, whoever is willing to be part of this little group. And I say small group being the operative word because we really don't want too many cooks in the kitchen. That can sometimes have consequences that we don't necessarily want. And this way, when you have a group of people working together, you can hear the different perspectives from different people, which you can benefit from in some circumstances. More people in your organization will become potentially familiar with the changes that you're working on sooner. If one person leaves the group, then the rest of the group can continue on with the work, and it's not falling all on the one person. And as I just mentioned, you can divide the work between these different members of this little group that you put together to make it a more manageable process overall. So a team approach when it comes to a small group of people involved in your organization, with the guidance of a lawyer, can be a very helpful approach to take with a process like this.
All right, perfect. So what risks can organizations face if they don't bring their constating documents into compliance with the ONCA?
So as of October 18th, 2024, which would be the end of the transition period, that 3-year period that you technically have to bring your documents into compliance, if you have any provisions at that point after the deadline that are not compliant with ONCA, except for a few exceptions, those provisions will be deemed to be amended to comply with the new legislation. So although the legislatures have not been entirely clear on what this will look like, we know that the Ontario Not-for-Profit Corporations Act default rules will apply to those provisions that are not compliant in some shape or form. Although we are not sure exactly what that will look like, as we do not have any case law on the matter, given that this time period has not expired yet. Legislatures are looking into it, and they're hoping to clarify this matter for us soon. But what we do know is that in some shape or form, the default rules under ONCA will just be deemed to automatically apply to these provisions that are not compliant, kind of whether you like it or not. So the issues that can arise with that, when you have deemed amendments without actual revisions to what you have written in your documents, you can then encounter this challenge of trying to determine which provisions are valid, which are not, which ones were deemed to be amended. Now we have to go back to the act and try to figure out what does apply and how it applies. So you're dealing with these challenges that you may not want to deal with, as they could potentially cause delays in meetings within the organization and in conducting business. And you don't want to experience unnecessary delays. So that's one of the important reasons to take your time now while you have it to try to work through those provisions and figure out what you should change and what doesn't need to be changed. There's also a risk that your organization might experience unintended consequences simply from ONCA's default rules. So ONCA has provided flexibility, as we've discussed throughout this webcast, in a number of areas, so that you will have the ability to tailor your provisions to your organization's specific needs. So take advantage of that, and don't let a situation arise where you're now subject to these default rules that may or may not be best suited for your particular organization. So while you have the opportunity, make those changes that are best suited. Now, you can change your bylaws and your letters patent at any time. It's not that when this transition period is over, you no longer have an opportunity to change your documents. That's not the case. You can still amend them in the future, but it will be a lot simpler of a process if you do it now before you have these random deemed amendments and you're trying to figure out what that looks like. And lastly, if you are a charity, if your corporation has charitable status or registration, your charitable registration could be at risk if you do not update your bylaws and file them with the CRA. So that's a really important piece if you are a charity.
All right, great. So I know that we did get a question inside of our chat with regards to the Ontario Business Registry. Well, we have that one covered, so we'll go into that now. So the Ontario Business Registry, it's our system for for ONCA. So how can organizations better navigate any changes that are needed given the difficulties currently with the system at hand?
So it's already been mentioned that ONCA took over 10 years, 11 years. It was passed in 2010 and it was only proclaimed in 2021. A big part of the reason for that was the underlying technology, the database that it's now relies on, which is called the Ontario Business Registry. So the Ontario Business Registry was launched the same date the ONCA took effect, October 19th, 2021. And it allows for organizations, Ontario corporations, whether business or nonprofit, to do all kinds of things online, such as amending your articles, such as updating your address, your directors, filing, which is filing your annual notice of change, etc. So you can do lots of things online now, which is great. You can do it in real time. It's supposed to speed up the time. And saves you a trip to Service Ontario offices if that's how you were filing before. Saves you a trip to the post office if you were mailing things in. So that's the great promise of the Ontario Business Registry. There have been some glitches. It was noted in the question that there are articles. Now I'm using the word articles in news articles. So there are some news articles saying how major law firms are essentially advising their clients to avoid Ontario altogether because of the glitches in the system. There are glitches for the nonprofit system as well as the for-profit system. So the answer to the simple answer to that question is, yeah, there are problems on both sides. So the answer is, what are these problems and how to best navigate them? So in order to access the Ontario Business Registry, organizations need three things. So one, they need a Service Ontario account, which you may already have to access other Service Ontario features. But if you don't, you can create it online. It's a username password kind of thing. Two, a one key. And again, this is a username password kind of thing that you use for various systems. If you are already on the Transfer Payment Ontario system, you will have a one key from that system, so you can reuse it here. If you don't, that's fine. You can create it online. The trickiness comes with the third thing you need, which is a company key. A company key is a PIN that's tied to your organization, so not the individual, the organization, which allows the organization to access the Ontario Business Registry and also allows the organization now to file forms by mail, because even the mail forms now require the company key. It's a unique PIN, so you shouldn't share it with anybody who you don't want to have access to be able to make changes on the Ontario Business Registry to your corporation. And the way you get it, and so this is where the troubles start. The way you get it is, so Google Ontario Business Registry, right? You go to the Ontario Business Registry webpage, you scroll down a bit, so there's a button that says order company key. Fine, so you click the button and it asks you for a name and an address. So anybody can order the company key. How is that possible that anybody can just order your company key? It's possible because they send the company key to your registered address. Now, if you are an organization who has not updated their address recently, that's a problem, right? Because the government's going to have the wrong address on the system. They're going to send the company key to the wrong address. However, even if you are an organization, so after that you may have been laughing to yourself, haha, those stupid organizations. We update annually, which is good. That's a great practice. Those organizations aren't stupid. There are lots of reasons why people lose track of filing. Even if you update it annually, there have been data migration issues, so that even if you update it annually, the government may still have the wrong registered address on record. So you may request a company key and it still gets sent to the wrong address. How do you avoid this problem? Well, you confirm you confirm by accessing the Ontario Business Registry that the government has the right address on file. How do you do this? So at the top of the Ontario Business Registry webpage, there's a search function, search the OBR. Let's see. So yeah, Barbara W. I ordered the company key system, said it was going to an address for 20 years ago, but the key was sent to the correct corporate address. Oh, that's very interesting. Okay, great. This is why I love doing these sessions. So I learn a great deal from them. Um, so that might lead you, if you've already ordered a company key, that might mean you want to wait a few weeks. Um, but to confirm that they have the right address on file, on at least publicly available, the way to do it is to search your organization and order a company profile. And unfortunately, until you get your company key, you have to pay a fee to order the profile. But it's highly advisable to order the profile to confirm that they have the right address on record, that they have the right directors on record. Now, if you've already ordered one, or if you want to order the company key anyway, even though they have the wrong address seemingly on file, then you're going to want to wait a number of weeks, because a lot of people have ordered their company keys. It's taking a little while. I've heard as many as 4 to 5 weeks. I've heard 1 to 3 weeks. So it takes a little while. One thing you may not want to do while you're waiting for your company key is order it again. If you haven't made change to your address, there may be no reason to order it again. What will happen if you order your company key again is they will issue a second company key that will cancel the first company key. So the way the system works is that every time you request one, it gives you a new PIN. This is done for security reasons, but the unfortunate consequence of this is that you may get your first company key in the mail and then it won't work, and that's going to be super frustrating. So make sure there aren't multiple people at your organization ordering the company key, which will lead to cancellations. 2, sit tight if you've ordered one and it hasn't come. 3, confirm by searching the Ontario Business Registry whether they have the right address or not. If all else fails and you want to just avoid this mess altogether, unfortunately, the only way that it seems open to still file changes to your address or changes to your articles is to go through a third-party provider like ONCA or Dye & Durham, and to pay them a fee, and then they have direct access to the system and they don't need a company key. So the Ontario Business Registry issues are ongoing. I'm going to put my email address in the chat here. If you're encountering issues with the Ontario Business Registry, feel free to send them to us at Ontario Nonprofit Network, because we're actively consulting with the government about this. The other thing I'll note about the difficulties with the Ontario Business Registry is that it requires you to give an address in order to access the system. That address now needs to be a physical address. It can't be a PO box. So if you're a rural or remote organization and you do not have reliable access to a physical address and you rely on a PO box, we acknowledge that this is a problem, and we're actively discussing this as part of our various priorities for improving the Ontario Business Registry. But unfortunately, I don't have any immediate solution for you.
Okay, wow, that is awesome. Thank you so much, Ben. Thank you so much, Jade. We are coming close to our ending time. We have about 12 minutes left. So I did want to note, we did have a question in the Q&A. Yes, we are recording this session. This session will be available on our website, on our YouTube channel, on our regular channels with for audio and visuals. And we will be giving you all a copy of that as a follow-up to this. As well, we have had a number of Q&A questions, but due to time, Ben and Jade have been amazing, and they've been answering the questions manually as they answer the questions that we have here. So I've been taking pictures of all of the questions. So just in the interest of time, we will be typing up those questions for you, and we'll send that as a follow-up as well, so you get access to that information too. So for the remaining Q&A questions, we have one question here where it says, could you clarify the audit requirement for a non-public benefit corporation with revenues that are less than $50,000? An audit is required unless a resolution is passed with less than 50% agreeing to waive. And then a minimum of a review engagement is required. Do I have that right? Is there any transition period?
Okay, so I'm I'll take this question. So I discussed with financial review earlier. So just to reiterate the question, so we're talking about an organization here that's not a public benefit corporation with annual review above $500,000. So the question is, what financial review does it have to get, and how does it get it? So just to reiterate, by default, an audit. But an organization that is not a public benefit corporation with annual revenue above $500,000 has the option of passing at a members meeting an extraordinary resolution, which means 80%, over 80% or more of member support to waive the audit and instead get a review engagement. So you do have that right. Regarding the transition period, so this raises an important question that I don't think we've touched on. Between now and 2024 period, your bylaws and your articles, your letters patent, the rules there, they continue to be valid, even if they don't comply with the ONCA. So it's only if they're silent, so if it doesn't talk about what financial review you need to get, then now it's the rules under the ONCA that apply to you. If they say something, then so for example, they may say you're required to get an audit, then those rules continue to be your rules until you change them.
Okay, great. So our last question in the Q&A, I know we have one or two questions in the chat, so we'll see if we can grab those as well. So this one says, the main address I use is an address that was in use during the initial times of COVID, but now the owners of the building are keeping the space for mail, but not in-person interaction. So keeping records in writing on site is not possible. What happens during that case? So I know, Ben, that you mentioned about digitizing records and ONCA's response to that. So maybe if we could elaborate there.
Yeah, so nonprofits are required to have a registered address, so some physical location. Various things attached to this registered address. So, by default, that's where you're expected to have your meetings. It's where the government is going to send you important documents like the company key. It's where members, for example, when they exercise their right to access certain documents, that is the location they have the right to access the documents at. By default. So it is required to have some address. So if the address isn't working anymore, and none of this is legal advice and so on, but practically speaking, you need to find some other physical address. So whether that's a personal address, and you may not want to use a personal address because it will be searchable through the Ontario Business Registry, or it's some kind of shared space, like in Toronto, they have the Centre for Social Innovation, that kind of place. There are lots of shared workplaces in Ontario. Then that's kind of what you're looking for. But yeah, this is definitely a time of change for real estate in the sector.
All right, great. So I know a few people put questions in the chat. We encourage, of course, to put your questions in the Q&A box, but we want to make sure we try and grab those before we go. Okay, so we have one question here. Do ex officio members have voting rights by right of office with these changes?
So that was a question that I actually addressed earlier in one of the answers to a previous question, but I'm happy to repeat the answer to that. So what's really important is that your bylaws, we suggest your letters patent, but as long as your bylaws set this out, it's okay, that they set out the different classes and groups of members in your organization that you have created. And as we talked about, there are different requirements under each one, how they can become a member in those groups or classes, how they can withdraw from membership, etc. One of those things being voting rights. So ex officio members are, if for anybody who doesn't know, would be a member that would automatically become a member by virtue of their office in a different capacity. So maybe they're a director, maybe they are an officer of the corporation, they're a president or a vice president, whatever it is. And maybe the bylaws state that if you are a director, you're automatically also a member, or if you're an officer, you're automatically a member. That's what an ex officio member is. So no, the answer to your question is no, they do not automatically have voting rights unless you have set that out in your letters patent or your bylaws that ex officio members, as a class or group of your members, has that right to vote.
All right, perfect. And we had one more question, I believe, inside of the chat. Let me just pull that up. How do you deal with the requirement for real signatures when minutes are digital?
So one of the things the ONCA does is recognize electronic signatures. So there are now options for that. Now, but this raises a broader question about, do you need to sign the minutes? And the answer is, it's a good practice which adds to the evidentiary value of the minutes. It's not an absolute requirement. So for example, if down the line you get sued and you want to point to the minutes and say, oh no, but we did our due diligence, and the other side wants to start poking holes in those minutes, right? Like, oh no, those don't actually reflect what really happened. Then one of the things that you might rely on is the fact that, oh, but these minutes are signed, so that person, like, they really attested to the fact that these are accurate, right? So it's more of a legal risk kind of analysis in terms of the practice of signing the minutes. But all that is just to say, I'll answer the question you actually asked, which is that electronic signatures are recognized. I can't get into the details though of different programs to do that. So there is a recommendation in the chat.
I will add just a quick note. Thank you, Benjamin. That was a great explanation. I will add a quick note, something to be aware of whenever you are dealing with digital signatures or using digital signatures, is that your digital signature must be an accurate representation of your actual signature. So if you're using, for example, Adobe or a program where you can type in your name, that's not something that we ever recommend or is really going to be accepted in a lot of circumstances, and it can cause you a lot of headaches. And the reason for that is because third parties who will view these signatures, or even parties directly related to your organization, they need to be able to confirm who indeed signed this. And although we are all aware of electronic signatures being quite messy and not a huge reflection of our actual signatures, make sure that you use the function where you can actually use your mouse and write, draw in your actual signature. So it's as close as possible to being a representation of your actual signature. And that will likely reduce issues in the future. And one other point is to keep in mind that if you are choosing to sign any kinds of corporate records or resolutions or things in a digital format, you can do that, but best practice is that you have a resolution passed by the directors permitting electronic signature and signature in counterparts, meaning that more than one copy of the same document can be signed independently, and together, combined, they count as one document. So best practice is to have a resolution by the directors signed, permitting the corporation to sign resolutions and corporate records by electronic means or in counterparts.
Awesome. That's great. Thank you so much. With 3 minutes to go, we might be able to entertain one more question, but I think it's time we probably wrap up. Thank you so much, Jade, and thank you so much, Benjamin, for your participation within this event. Again, everyone, this event is titled The New Ontario Nonprofit Corporations Act: What Ontario Nonprofit and Charity Organizations Need to Know About the ONCA. And thank you so much. This was so packed with such comprehensive information. And of course, we had you speaking on camera and also helping us manually with the chat. As we said, this event is being recorded. We will collect all the questions that weren't answered directly on camera, and we'll provide you with that list as well, so you can enhance your learnings. And yes, we'll share any resources with you from our speakers, to their emails, their links, as well as the resources that they have provided with us to share with you following the event. Thank you, everyone, so much. Ben, Jay, do you have anything you'd like to say in closing?
There are lots of details, but don't lose sight of the bigger picture. It could be a very draining experience, but it can also be a time of renewal. And ultimately, we hope your organization comes out better for it.
Same for me. I wish you all the best. We truly hope that this new act will relieve many of you from the challenges and issues that you faced when governed by the Corporations Act. and that your future with your organization is bright.
All right, perfect. Thank you so much, everyone. We will definitely see you all another time with a new webcast. Thank you all so much for attending. We appreciate it. Bye now.